Hello friends and welcome. Today we shall discuss false imprisonment, which is a civil wrong under law of torts. The main objectives of today's deliberation are: first, we shall try and understand the basic concepts of false imprisonment. We shall also try to know the essentials of false imprisonment. And finally, we shall try and understand the defenses to false imprisonment. Let me first of all give you a brief introduction about false imprisonment. Restraint on the liberty of a person is an offense. It may be either wrongful restraint or wrongful confinement. In the former, a person is prevented from proceeding in any direction in which that person has right to proceed, while in the latter, a person is prevented from proceeding beyond certain circumscribing limits. False imprisonment is that form of confinement which consists of imposition of a total restraint upon the liberty of another for some period, howsoever short, without sufficient lawful justification. To constitute this wrong, imprisonment in the ordinary sense is not required. When a person is deprived of his personal liberty, whether by being confined within the four walls or by being prevented from leaving the place where he is, it is false imprisonment. If a man is restrained by a threat of force from leaving his own house or an open field, there is false imprisonment. The essentials required to constitute this wrong are: there should be total restraint on the liberty of a person, and it should be without any lawful justification. Now let's discuss these essentials in detail. First, total restraint. Both total and partial restraint is actionable under criminal law. In total restraint, a person is prevented from going out of certain circumscribed limits as defined in Section 340 of IPC. On the other hand, when the restraint is not total but it's only partial, and a person is prevented merely from going to a particular direction where he has a right to go, it is wrongful restraint according to Section 339 of IPC. But under civil law, the position is different. The tort of false imprisonment is constituted when there is a total restraint. It is no imprisonment if a man is prevented from going to a particular direction, but he is free to go to any other direction. To constitute this wrong, a person must have been completely deprived of his liberty to move beyond certain limits. If a man is prevented from going to a particular direction but is allowed to go back, there is no false imprisonment. In Bird versus Jones, a part of the public footway as opposed to a carriageway on Hammersmith Bridge was wrongfully enclosed by the defendant. Seats were put there and entry to the enclosure was allowed only to those who made the payment to watch the rowing there. The plaintiff asserted his right of using this footway, climbed over the fence of the enclosure but was prevented to go forward. He remained there for about half an hour and subsequently brought an action for false imprisonment. In this case, it was held that there was no false imprisonment as there was no total restraint on the plaintiff's liberty, the plaintiff being free to go back or even to cross the bridge through the carriageway. It was observed by Justice Patterson, quote, "I cannot bring my mind to the conclusion that if one may merely obstruct the passage of another in a particular direction, he can be said thereby to imprison him." Therefore, we can say that only total restraint results in false imprisonment, however short its duration may be. Also, in Me versus Cruikshank, after his acquittal, a prisoner was taken down to the cells and detained there for a few minutes while some questions were put to him by the warders. There was held to be false imprisonment. For false imprisonment, it is not necessary that a person should be imprisoned in a jail or confined within the four walls of a building. If there is some restraint which prevents a person from having the liberty of going beyond certain circumscribed limits, there is false imprisonment. Detention may be even on a highway or moving object like a bus or a train. As stated by Justice Coleridge in Bird versus Jones, a person may have its boundary large or narrow, visible and tangible, or, though real, still in the conception only. It may itself be movable or fixed, but a boundary it must have, and that boundary the party imprisoned must be prevented from passing. He must be prevented from leaving that place within the ambit of which the party imprisoning would confine him, except by prison breach. Some confusion seems to me to arise from confounding imprisonment of the body with mere loss of freedom. It is one art of the definition of freedom to be able to go wherever one pleases, but imprisonment is something more than the mere loss of this power. It includes the notion of restraint with some limits defined by a will or power exterior to our own. For such a wrong, therefore, the place of detention may be a common prison, a room, or even a street. Locking a person inside his own house is false imprisonment provided the restraint is total and he does not have any way out. Use of physical force is not necessary. Threat to use force if a person leaves certain circumscribed limits is enough. Preventing a person from getting out of certain premises is false imprisonment, but not providing facilities to a workman to get out of a mine when there is no such obligation to take him out is not false imprisonment. Here it's pertinent to mention the significance of means of escape. If there are means of escape, the restraint cannot be termed as total, and that does not constitute false imprisonment. That is, means must be intelligible to the person detained. For instance, if the captive is a blind man or a child, he should be in a position to locate the means. The means must also provide a reasonable way of getting out of detention. If the window providing escape is so high that there is likelihood of injury to the escaping person, or even if an outlet is there, but there is a threat of violence to the escaping person, such means of escape are of no significance and the detention amounts to false imprisonment. There has been a difference of opinion on the point whether the knowledge of the plaintiff is essential to constitute the wrong of false imprisonment. In Herring v. Boyle, it has been held that such knowledge is essential. In that case, a schoolmaster wrongfully refused to permit a schoolboy to go with his mother unless the mother paid an amount alleged to be due from him. The conversation between the mother and the schoolmaster was made in the absence of the boy, and he was not cognizant of the restraint. It was held that the refusal to the mother in the boy's absence and without him being cognizant of the restraint could not amount to false imprisonment. In Meering v. Graham White Aviation Company, it has been held that the knowledge of imprisonment is not an essential element for bringing an action for false imprisonment, because the wrong could be constituted even without the person having the knowledge of the same. According to Justice Atkin, quote, "It appears to me that a person could be imprisoned without him knowing it. I think that a person can be imprisoned while he is asleep, while he is in a state of drunkenness, while he is unconscious, and while he is a lunatic. Those are cases where it seems to me that the person might properly complain if he was imprisoned, though the imprisonment began and ceased while he was in that state. Of course, might be diminished and would be affected by the question whether he was conscious of it or not." In Meering's case, the plaintiff, an employee of the defendant company, was suspected of having stolen the company's property. He was called to the company's office and was asked to stay in the waiting room. He was told that his presence was required for investigation in connection with the property which had been stolen. One or two employees remained outside the room where the plaintiff had been made to sit. In the meantime, the police was called and the plaintiff was arrested on the charge of theft. He was acquitted and then he sued the defendant for false imprisonment. It was held that the policemen were not acting as the company's agents and arrest of the plaintiff by them on sufficient reasonable grounds of suspecting theft was not wrongful. It was, however, also held that the detention of the plaintiff by the officers of the company before the policeman had arrived was wrongful and that amounted to false imprisonment. The fact that while the plaintiff was in the waiting room, he did not have the feeling of him being wrongfully detained did not make much difference, because when a person is detained, those detaining him may be anxious to make him believe that he is not in fact being imprisoned, and at the same time his captors outside the room may be boasting to persons that he is imprisoned. Street is of the opinion that the knowledge of confinement ought to be required because the interest protected seems a mental one, as an assault, and Herring's case is to be preferred to the Meering's case. Meering's case has also been criticized by Goldhart in Restatements of the Law of Torts, 1935. Prosser has, however, supported Meering's case. The decision in Meering's case appears to be more logical. Moving on, let's now come to the second essential required to constitute the wrong of false imprisonment, that is, it should be without any lawful justification, or in other words, we can say it is an unlawful detention. In order to constitute the wrong of false imprisonment, it is necessary that the restraint should be unlawful or without any justification. If a person is not released from jail after his acquittal but is continued to be detained thereafter, the detention cannot be considered to be lawful. In Rudal Shah v. State of Bihar, the petitioner was acquitted by the court in 1968 but was released from the jail in 1982, that is 14 years thereafter. The state tried to justify the detention by pleading that the detention was for the medical treatment of the petitioner for his mental imbalance. The plea was rejected. As an ancillary relief in a writ of habeas corpus by the petitioner, a sum of Rs 35,000 was granted as compensation as an interim measure by the Supreme Court without precluding the petition from claiming further compensation. Similarly, in Bhim Singh v. State of J&K, the detention was unjustified. In this case, the petitioner, an MLA of the J&K Assembly, was wrongfully detained by the police in order to prevent him from attending the Assembly session. The act of arrest was considered to be mischievous and malicious, and the Supreme Court considered it to be an appropriate case for granting exemplary damages amounting to Rs 50,000. In Garikipati v. Araza Biksham, the defendant made a false report to the police that the plaintiffs were instrumental in setting fire to the defendant's property. The plaintiffs were arrested by the police, but since the charge was false, they were discharged. The defendant, having made the complaint without any justification, which resulted in the arrest of the plaintiffs, was held liable for false imprisonment. If a police officer orders an arrest without having such a power, he is responsible for the same. The case of Kundal Lal versus Dr. Desraj is an example of the same. In that case, the surety applied for the cancellation of a bond. The superintendent of police cancelled the bail bond and ordered the rearrest of the plaintiff. In accordance with those orders, the plaintiff was rearrested by a sub-inspector. The power to cancel the bail bond and to order the rearrest could be exercised only by a magistrate under the Criminal Procedure Code. It was held that since the superintendent of police did not have such a power, his orders and consequential rearrest of the plaintiff were unlawful, and both the superintendent and the sub-inspector were liable for false imprisonment. Friends, when there is some justification for detaining a person, there is no false imprisonment. Thus, if a man entered certain premises subject to certain reasonable conditions, it's no wrong to prevent him from leaving those premises and unless those conditions are fulfilled. In Robinson versus Balmain New Ferry Company Limited, the plaintiff entered the defendant's wharf with an idea to cross the river by one of the defendant's ferry boats. Finding that no boat was available for another 20 minutes, he wanted to go out of the wharf. The plaintiff had paid a penny for entry but refused to pay another penny, which was chargeable for exit, according to the rules of the defendants as displayed on the notice board. The defendants disallowed him to leave the wharf unless payment for exit was made. In an action for false imprisonment, it was held that the defendants were not liable as the charges were reasonable. Similarly, when there is volenti non fit injuria on the part of the plaintiff, the defendant cannot be made liable. In Heard versus Weardale Steel, Coal and Coke Company, the plaintiff, a workman in defendant's colliery, descended the mine with the help of a cage in the beginning of the shift at 9:30 a.m. Ordinarily, he would have been entitled to ascend the shaft by means of the cage at the end of the shift at about 4 p.m. He and some other miners, when directed to do certain work, wrongfully refused to do the same, considering that to be unsafe. And at about 11 a.m., that is much before the usual time for ascending the shaft was there, they requested the foreman to allow them to ascend the shaft by means of the cage, as they wished to leave the mine. Meanwhile, the cage started working, but these workmen were allowed into the cage at about 1:30 p.m. and then the plaintiff was taken to the top. The plaintiff then sued the defendant for false imprisonment. It was held that there was no false imprisonment because it was a case of volenti non fit injuria insofar as the plaintiff had entered the mine knowing that the workman would be taken out on the top at the end of the shift, and he had no right to call upon the employers to make use of the cage to bring him to the surface just when he pleased. It was said that the position here was similar to that of a man who gets into an express train and the doors are locked, pending its arrival at its destination. He is not entitled merely because the train has stopped by signal call for the doors to be opened to let him out. He has entered the train on the terms that he is to be conveyed to a certain station without the opportunity of getting out before that, and he must abide by the terms on which he entered the train. Law permits the arrest of a person when he has committed some offense. Such arrest may be made by a magistrate, a police officer, or a private individual according to the circumstances mentioned in Chapter 5 Criminal Procedure Code 1973. A private person may arrest any person who, in his view, has committed a non-bailable and cognizable offense or is a proclaimed offender. After making such an arrest, he should, without unnecessary delay, make over the arrested person to a police officer of the nearest police station. Arresting a person when the same is neither permitted by the provisions of the Criminal Procedure Code nor otherwise justified will amount to false imprisonment. It has been noted that when a lawful arrest has been made by a private person, the detained person must be handed over to the police as soon as it is reasonably possible thereafter. The detention by a private person will amount to false imprisonment even if such a person is found guilty at a subsequent trial. In John Lewis and Company versus Times, the plaintiff and her daughter went to a shop where the daughter committed theft and put 4 calendars into her mother's bag. Both the plaintiff and her daughter were detained in the office and were told to wait for the managing director's decision, where they remained for about an hour. He decided to prosecute them and they were handed over to the police. On trial, the daughter was found guilty of theft, but the charge against the mother was dropped. The mother sued for false imprisonment. The defendants were held not liable. It may be noted here that it is not for the plaintiff to prove that the imprisonment had been without justification. The plaintiff's case is complete when he proves that he had been detained by the defendant or his agent. In case the defendant wants to avoid the liability, he has to prove some lawful justification for the detention. Judicial Officers Protection Act 1850 grants protection to judicial officers for anything done or ordered to be done by them in discharge of their judicial duty. A person arrested by the orders of a judicial officer cannot sue the judicial officer for false imprisonment or for any other wrong. The protection is granted even if the judicial officer exceeds his jurisdiction, provided that he honestly believed himself to be having jurisdiction to do that act. Such a protection is not available if the magistrate acting mala fide exceeds his jurisdiction. Thus, a magistrate, if acting mala fide illegally and outside his jurisdiction, orders an arrest, he is not entitled to the protection granted by the Judicial Officers Protection Act 1850 and would be liable for false imprisonment. The protection of judicial privilege is available only if the officer is acting judicially. In state of UP versus Tulsi Ram, an officer wrongfully ordered the arrest while acting in his ministerial or administrative capacity. He was held liable for false imprisonment. Finally, friends, let's highlight some remedies for false imprisonment. First, action for damages. Whenever the plaintiff has been wrongfully detained, he can always bring an action to claim damages. Compensation may be claimed not only for injury to the liberty but also for disgrace and humiliation which may be caused thereby. Second, self-help. This is the remedy which is available to a person while he is still under detention. A person is authorized to use reasonable force in order to escape from detention instead of waiting for a legal action and procuring his release thereby. Third, habeas corpus. It is a speedier remedy for procuring the release of a person wrongfully detained. Such a writ may be issued either by the Supreme Court under Article 32 or by a High Court under Article 226 of Constitution. By this writ, the person detaining is required to produce the detained person before the court and justify the detention. If the court finds that the detention is without any just or reasonable ground, it will order that the person detained should be immediately released. Thus, friends, from the discussion it is clear that false imprisonment means total restraint for some period, however short, upon the liberty of another without sufficient lawful justification. This restraint should be total on the liberty of a person. Self-help, habeas corpus, action for damages are the remedies in case of false imprisonment. That is all we have for you in today's lecture. Hope you have understood it well. Thank you and goodbye.